Hello, everyone, and welcome to the Crypto Law Show. My name is James Murphy, and I'm your guest host for this week's show. I'm also known as Meta Lawman. We're going to have some fun talking about crypto law, so suitable for the name of the show. I'm going to go over three cases. My appeal of the FOIL request, the New York Department of Financial Services. We're going to talk about the Ripple case, and in particular, the damages part of that case. And then we're going to talk about the most recent ruling in a CoinBase case. Now, one thing to remember is this is not legal advice. I am a lawyer, just not your lawyer. So let's jump right in with the first topic, which is my information request to the New York Department of Financial Services. So many of you have heard of the phrase FOIA, F-O-I-A, which stands for Freedom of Information Act, and that applies to the federal government and federal agencies. And you can make requests to federal agencies for information and data concerning the operations of our government, and that's a good thing. The New York Department of Financial Services and New York in general has a very similar process, but it's called FOIL, ends with an L, which just means Freedom of Information Law. So let me give you a little background before we do the deep dive into where things stand with my FOIL request. In September of last year, the New York Department of Financial Services decided to remove XRP from its green list, which is a list of approved digital assets for custody and or for trading, which means if the asset's on the green list, then an exchange that has a BIT license from the New York Department of Financial Services can offer that digital asset to customers in New York. That's the purpose of the green list. Now, it's not the exclusive list of assets that can be offered, but there's a whole different process. If you want to go off the green list and get something listed, you have to go through another process with the New York Department of Financial Services. So anyway, in September of 2023, the New York Department of Financial Services came out with an update. They called it an update of their green list, and that update removed XRP from the list, as well as a number of other tokens. It was not just XRP. Now, I found that a little odd, given the fact that in July, just 2 months earlier, Judge Torres in the Southern District of New York in Manhattan had ruled that the XRP token is not a security. And so the removal of XRP from the green list, I found puzzling. So I decided to ask in a legal way the Department of Financial Services two things. One, how did you decide that it would be a good idea to remove XRP? And secondly, who did you talk to about this? Were there other agencies, state, federal, or international securities regulatory agencies that you discussed this with before making this decision? So I sent in that request, followed all of the legal requirements, and my request was rejected at the end of December. And the Department of Financial Services said, you have no right to any of these documents. And they also claimed that they didn't have any documents regarding their communications with other agencies of the government. And so I disagreed with that ruling and filed an appeal. Now, interestingly, in New York, an appeal of the denial of the FOIL request goes to the agency that denied the request. So I have submitted an appeal to the New York Department of Financial Services, the same entity that rejected my request in the first instance. The background there is they're supposed to decide that appeal within 10 days. And then thereafter, if they affirm the decision of their colleagues at the same agency to deny my request, then I move on to court. to proceed to assert my right to see these documents. So 10 days came and after my appeal, and I got an email from the New York Department of Financial Services appellate office saying that they were going to extend their deadline, but they didn't say what the new deadline was. So it is in essence a indefinite extension that they have declared for themselves. So what I thought we'd do is just take a look at what my appeal, what I said in my appeal, some excerpts of it, so you understand the basis for my argument that these documents ought to be made available to the public. So let's take a look at that appeal. And so this is the first page of my appeal where I'm spelling out the rationale for what we're asking for. And so in March, the New York Attorney General, Letitia James, alleged that the Ethereum token is an unregistered security under both New York and federal law. Now, it's important to understand that the New York Attorney General is the highest ranking law enforcement official in New York. So let's take a look at the next page where I say, I don't know if this is too small. Certainly, if you're watching this on your phone, I'll just read this for you. The Attorney General made no secret about her legal determination that ETH is a security. The Attorney General issued a press release emphasizing that, quote, this action is one of the first times a regulator is claiming in court that ETH, one of the largest cryptocurrencies available, is a security. Interestingly, that's the end of the quote. Interestingly, the Attorney General did not allege that XRP was a security, even though XRP was listed for trading on the KuCoin trading platform, which was the defendant in this case filed by the Attorney General. So the Attorney General, the highest law enforcement officer in New York, declares ETH is a security and does so in a legal filing in the state court in New York in March. Then 4 months later, July of 2023, Judge Torres rules that the sales of XRP tokens by Ripple and by senior executives at Ripple on crypto exchanges did not constitute sales of securities. So that was July of 2023. 2 months later, that takes us to September of 2023, the Department of Financial Services removed XRP from the green list while retaining ETH on the green list. I found that peculiar, and that's what prompted me to file the FOIL request. So if we go to the last page of this appeal, I kind of sum it up for the powers that be at the New York Department of Financial Services to try to encourage them to do the right thing here with this request. And here I say, the decisions to A, delist XRP after a federal judge ruled that XRP is not a security, and B, retain ETH on the green list after the highest ranking law enforcement official in New York determined that ETH is a security, gives rise to reasonable questions in the minds of the public and regulators around the world about what possible rationale DFS could have for these paradoxical decisions. And I finished off by saying the DFS prides itself on transparency. And I suggested that this would be a really, really good idea for them to be transparent about how they arrived at this paradoxical decision. Because as I've said a number of times, there could be a perfectly good explanation for this decision. I just can't imagine what it is. I'm really curious, and I think the government of New York ought to want to reveal to the investing public and to the general public how they arrived at this curious decision to retain ETH on the green list, even though the Attorney General says it's a security, and to get rid of XRP from the green list, even though a federal judge who's kind of an expert in federal law and securities law says it's not a security. So I found that puzzling. And now I'm waiting for a ruling on my appeal. And in the event the appeal is denied, then I will proceed to court to press for, the information that I think all of us deserve, an explanation of how they arrived at this decision. So that's where things stand on my FOIL appeal, and I look forward to keeping everyone advised on that as it proceeds. So the next thing we'll talk about is Ripple, and in particular, the damages phase that we're in right now, the remedies phase. And so the SEC last week filed its brief explaining its remedies theory. And what they asked for is disgorgement of about $876 million. And under the law of disgorgement, you get interest. You get to recover interest on that number if you're successful in getting disgorgement. And the way the SEC calculated it, that's close to $200 million in interest on the disgorgement. And then finally, they asked for a penalty also of $876 million, which adds up to roughly $1.95 billion, which is a lot of money. And so, interestingly, there's been a development in the law since this case was filed that really throws a monkey wrench into the SEC's theory. And that is, in order to receive disgorgement against a defendant, the SEC must demonstrate that there are victims of the violative conduct. And here, the violations that Judge Torres found were sales of XRP to institutional investors pursuant to contracts. She did not find securities violations for sales of Ripple to retail investors through exchanges, or sales by Garlinghouse or Larson through exchanges to retail. Those were found to not be investment contracts and not securities. So the only thing we're talking about are the sales to these big institutional investors, hedge funds, etc., that were face-to-face, in essence, transactions documented by a contract. And now the law changed at the end of last year to say that the SEC has to show that there are victims. Now, the problem is they filed their brief last week, and did not cite any victims. And so let's take a look at the case law, the case from the Second Circuit that really changed how we look at these cases involving disgorgement. What I'm about to show you here is not what the law was when I was practicing law for many years actively in New York and other places. So let me read this to you slowly. And it says, this is the Second Circuit. And so the courts within New York, the Southern District of New York, including Judge Torres, must follow precedent of the Second Circuit. And so the Second Circuit has said recently, disgorgement remedies under the securities laws are subject to the traditional equitable limitations. One of those equitable limitations is that disgorgement must be awarded for victims. A defrauded investor is not a victim for equitable purposes if he suffers no pecuniary harm, because the district court in this case did not find that the investors in this case suffered such harm. The district court abused its discretion when it concluded that disgorgement was authorized. So let's move on to the next page here. And this is in a footnote. And see, this is what lawyers do. This is what we're trained to do. We can't help ourselves. We read the footnotes. We read the small print. And here, Footnote 16 in this opinion of the Second Circuit gives some interesting detail about how to go about analyzing this disgorgement remedy. It says, the district court may have presumed that the investors suffered economic harm by definition when capital they had invested in the company for corporate purposes was looted by an insider. But whether the investors actually suffered pecuniary harm would depend on the type of securities held, the terms of those securities, and importantly, when those securities were sold. And so that's the end of that quote. And the reason I highlighted when the securities were sold, it's the only way to assess whether there are actual damages suffered by victims. And so I need to reiterate here that in this instance, for this analysis, the question is not whether retail investors have suffered losses, because surely many have, who have traded over the years. There are losers and there are winners. The question is those who are the quote unquote victims of the violation of the securities laws are these big institutions, all of whom, or most of whom, received XRP at discounts, presumably significant discounts, and apparently profited from the transactions when they resold the XRP that they received from Ripple. And the reason I say apparently is because the SEC in its brief doesn't identify a single institution that lost money as a consequence of its dealings with Ripple and subsequent sales of XRP. Instead, it points to the fact that certain institutional investors received less of a discount than other institutions, depending upon factors in these contracts and when these transactions were consummated. And so that's the pecuniary harm that the SEC is asserting, but under the Second Circuit, that does not work, in my opinion. If you remember that footnote, it says you got to see what they sold it for to analyze whether they actually lost money. And there is nothing in that brief from the SEC saying this institution lost money from transacting with Ripple and subsequently selling the XRP. There are these theories about enormous pecuniary harm because some of them didn't get as much of a discount as others, but that doesn't work, in my opinion, under the Second Circuit decision. Now, the caveat is there are some redactions in this brief, but I don't believe those redactions are covering this situation of identifying an actual honest-to-God victim. And so this is big. What happened was this case was sent back to the district court, Southern District of New York, same court where Judge Torres is, and Judge Fela and Judge Rakoff, all of them in that same building. It was sent back to them, and the SEC sent a letter to the judge saying, we're thinking about appealing this to the U.S. Supreme Court because we don't agree with the Second Circuit decision about requiring the SEC to prove that there's some victim in the case. But ultimately, they said they decided not to appeal to the Supreme Court. And so the case is basically back at the district court, and nothing has happened yet since it was remanded to the district court. Now, I should add as well that Ripple has another really good argument, and that is under the U.S. Supreme Court case of Morrison, that the SEC does not have jurisdiction over transactions that don't happen in the United States. Morrison and what we call its progeny, which means cases that come after Morrison, that interpreted Morrison, adds a lot of complexity to the analysis of what transactions have a sufficient connection to the United States and which do not. But interestingly, as far as I can tell, the SEC made no effort to identify whether transactions between Ripple and these institutional investors occurred in the United States or not. So I expect that Ripple is going to come back hard with their Morrison argument, as well as this no victim argument as well. Now, that does not mean that the answer is zero in terms of a damages award. The request for damages, for remedies by the SEC falls into three buckets: disgorgement, interest on disgorgement, and then something called a penalty. And there's a statute that explains how to calculate the maximum possible penalty, but the court is not required to award the maximum penalty. And if it comes out that there are no victims among these institutional investors, is a pretty good argument that there shouldn't really be an enormous penalty. Again, in my opinion, if I were the judge and there's no victims, I would not be looking to award an $876 million penalty, but that's just me. Let's see here. Let me see. Ripple is coming back with their brief, I believe, next week. So we'll see if I'm right about what arguments they're going to make, but it'll be fascinating to see. And I will certainly, share my take on the Ripple arguments when that comes out, I think April 22nd. So that's where we stand on Ripple damages. And lastly, I wanted to talk about this very recent case involving CoinBase, because I am a little bit concerned that the analysis that you're seeing on Twitter, as well as some other kinds of publications, really crypto industry publications, their take on what happened there is not exactly correct. What happened there is private individuals were suing CoinBase, trying to assert a class action of people who transacted on the Coinbase platform. And they're alleging that Coinbase sold them unregistered securities. And as a seller, they have a right to rescind the transactions because the securities, the alleged securities, are unregistered. And that's how that works. You're right. Your remedy is rescission. The Second Circuit wrote a very short opinion and remanded it back to the district court judge, who had dismissed the case in its entirety. So the plaintiffs appealed to the Second Circuit, and the Second Circuit remanded and said, not so fast on this dismissal, and said that the court relied on a contract from December of 2021, where Coinbase said, be aware, you're not buying these tokens from us, you're buying them from the seller on the platform. Now, anybody who has an account on Coinbase, I believe, understands that's how it works. You're not buying Cardano from Coinbase, you're buying Cardano from a seller who's providing, liquidity on the sell side, and you're taking that, or whatever. If you're doing a market trade, or you're posting your own liquidity with a limit order, or whatever it might be, but you're not trading with Coinbase. Coinbase is providing the platform for that to happen. And so the judge relied on an agreement that makes that very, very clear. And the SEC said, the Second Circuit said, well, wait a minute, there's other contracts during this class period other than the one that was cited, and it was cited in an earlier complaint. So you got to go back and sort of redo this analysis, district court judge. But the court did agree with dismissing the Securities Act claim, this other claim, the Exchange Act claim, which we call the 34 Act. And now it's getting a little complicated, I understand. But the judge found that it was appropriate to dismiss the 34 Act claim because the plaintiffs had not articulated specific the terms of contracts that can be rescinded in the context of the the Exchange Act claim, the 34 Act claim. So people have taken from this the idea that there's been a declaration that trading on Coinbase or any other exchange has been determined to be not securities transactions. And unfortunately, that's not correct. And again, we're going to have to go to the decision and a footnote in the decision. So let's take a look at this. I think it's called Oberlander versus Coinbase, and was decided by the SEC. And this is by the Second Circuit. And this is footnote number 1. It says Coinbase does not contest for purposes of the motion to dismiss that the tokens are securities under the Securities Act, as well as the Exchange Act, but reserves the right, as it did in the district court, to address that issue should plaintiffs' claims survive the motion to dismiss. So we can be sure that the Second Circuit has not declared that trading on exchanges is not securities transactions, because that issue was specifically reserved by Coinbase and not ruled on by the Second Circuit. And so there's been a little bit of a misunderstanding, I think, on X and some analysis that I've read, that this really doesn't mean a whole lot for the SEC's case against Coinbase, because the focus there is not on whether Coinbase was a seller of the tokens, which we kind of know they weren't, but rather whether they provided a platform as an exchange, or are they assisted in the transactions and got paid a commission as a broker or dealer, or that they are a clearing agent for securities transactions if these tokens are deemed securities. Those are different issues than whether Coinbase itself is a seller. So unfortunately, this is not really a big impact, or much of an impact at all, on the SEC versus Coinbase case. And I know people hate to hear that, but when Meta Lawman's going to give you my analysis, whether we like it or not, I still believe that Coinbase is correct, that these tokens are not investment contracts at all, and that there's 90 years of case law, or more, actually more, to support that idea. And whether Judge Fela gets that right, I'm pretty optimistic that the Second Circuit and certainly the U.S. Supreme Court is likely to get that right. Last thing on what's going on at the Second Circuit, this is a little bit of sort of inside baseball and tactics and whatever, but Judge Rakoff presided over the Do Kwon trial, and to absolutely nobody's surprise, the jury found Do Kwon liable for selling the Terraform Labs token and the stable coin. And if they appeal, unfortunately, that may be the first case to go up to the Second Circuit. And that's not the best case. It's not the best set of facts, because Do Kwon basically violated every instruction any competent lawyer would have given him about how he went about distributing those tokens and representing to people that it was just like equity. That was a big no-no. But in any event, I'm sure if they do appeal, that there will be a lot of amicus briefs and whatnot. But it is a little unfortunate that the one with not really good facts may be the first one that the Second Circuit gets a crack at determining this question of whether digital assets like that are investment contracts. So anyway, the clock on the wall says I've used up all of my time, and I really enjoyed doing this. There's so much else going on. So many people want me to talk about the Richard Hart thing, or the Stephen Narayoff, thing that he filed today. So much stuff going on. I can only address a little bit in the time allotted here. And so thank you so much, everyone. I look forward, in terms of if there are any XRP community people watching, I look forward to meeting you at XRP Las Vegas at the beginning of May. I'll also be at Consensus at the end of May, and look forward to meeting as many of you as I can at that time. I want to thank very much the great staff at Crypto Law. Blaine and Abby, fantastic job supporting me. I don't know what I'm doing, just functioning here out of my office, trying to figure out all this technology, and your help was really wonderful. So listen, thank you so much for listening to me in this long monologue. Really appreciate all your support on X. And that's all for now. And I guess it's Metal Lawman out.